In this lecture, we shall discuss the supremacy and interpretation of the 1992 Constitution of Ghana. The supremacy and interpretation of the 1992 Constitution of Ghana. We shall also look at the categories of persons that have capacity to bring an action to enforce the supremacy of the 1992 Constitution. Must it be any person at all who can bring an action to enforce the supremacy of the Constitution? We shall address that in this lecture. We shall also look at the courts that has jurisdiction for the interpretation and enforcement of the 1992 Constitution of Ghana. So that if you want to enforce the supremacy of the Constitution, or if you want to go for an interpretation or enforcement of the Constitution, which court has the jurisdiction for such interpretation or enforcement? And then we shall also seek to find out the test for determining whether a question related to the interpretation of the Constitution has arisen. In other words, can you just wake up and just say that you are going to the court for an interpretation of the Constitution? What is the test that has to be satisfied before we can conclude that a question related to the interpretation and enforcement of the Constitution has arisen? Having set out what we shall be discussing in this lecture, we shall now begin with Article 1 Clause 2 of the Constitution. Article 1 Clause 2 of the Constitution affirms the supremacy of the Constitution. It clearly lays down that the Constitution shall be the supreme law of Ghana. It reads as follows, Article 1 Clause 2. The Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this Constitution should, to the extent of the inconsistency, be void. Article 1 Clause 2 clearly therefore lays down the supremacy of the 1992 Constitution. It says, the Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of that inconsistency, be void. Now, Article 2 of the Constitution is the clause that seeks to protect Article 1 Clause 2. So that even though Article 1 Clause 2 lays down the supremacy of the 1992 Constitution, Article 2 of the Constitution sees to the protection of the supremacy of the Constitution. Article 2 provides that when any person identifies that there is a breach of the supremacy of the Constitution, Article 2 empowers such a person to bring an action in the Supreme Court for a declaration to the effect that there is a breach of the 1992 Constitution. Now, I take the view that Article 2 protects Article 1 Clause 2 because if you don't give people the right to bring an action to the Supreme Court to seek for a declaration and challenge actions that violates the supremacy of the Constitution. If you don't give people that right, then when people breach the supremacy of the Constitution, what then do we do? That is why I take the view that Article 2 of the Constitution sees to the protection of the supremacy of the Constitution that has been provided for under Article 1 Clause 2. So Article 2 of the 1992 Constitution reads as follows, and I quote. It reads that a person who alleges that A, an enactment or anything contained in or done under the authority of that or any other enactment, or B, any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution, may bring an action in the Supreme Court for a declaration to that effect. So therefore, it is important to note the language of Article 2 of the Constitution. It gives capacity to someone that has been described as a person. Article 2 says a person who alleges. So our next question is that, who is this person? Who is this person? Can it be just any person at all in Ghana? Who is this person? Now, before we look at who this person is, let us also take a look at Article 130 of the 1992 Constitution, which also vests exclusive original jurisdiction in the Supreme Court in relation to any question or matter that relates to the enforcement or interpretation of the Constitution. Article 130 reads as follows. Subject to the jurisdiction of the High Courts in the enforcement of the fundamental human rights and freedoms, as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in A, all matters relating to the enforcement or interpretation of this Constitution, and B, all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person or by law or under this Constitution. So under Article 130 Clause 1A, the Supreme Court is given exclusive original jurisdiction in all matters relating to the enforcement or interpretation of the 1992 Constitution. Now, having established that the Supreme Court is the one that has exclusive original jurisdiction in all matters relating to the interpretation or enforcement of the Constitution, let us come back to Article 2. Who are the categories of persons that have the right to bring an action under Article 2 to enforce the supremacy of the 1992 Constitution? Article 2 says as follows. It says, a person who alleges. So the question then is that, who is this person that can bring an action under Article 2 of the Constitution to see to the interpretation and enforcement of the Constitution? The reason this question is important is that some persons have argued that before a person brings an action under Article 2 to enforce the supremacy of the Constitution, that person must not be a busybody. He must be somebody who has a personal interest in the outcome of the matter. This is the argument that some persons have raised. But that is a wrong position. The right position is that for a person to have capacity to bring an action under Article 2, that person must be a citizen of Ghana. Full stop. The moment the person shows that he's a citizen of Ghana, then even though he may not have a personal interest in the outcome of the matter, such a person has capacity to bring an action to enforce the supremacy of the Constitution. Therefore, the expression "a person" that has been put under Article 2 of the 1992 Constitution refers to any citizen of Ghana, regardless of whether the person is someone that has a personal interest in the outcome of the matter or not. Now, the case, or let me say one of the cases that has answered this question is the case of Sam versus Attorney General, number 2, reported in 1999, 2000, 2 Ghana Law Reports at page 336. This is the holding of the courts as captured in holding 1 of the head notes, and I quote, "The original interpretative and enforcement jurisdiction of the Supreme Court under Article 2(1) of the Constitution, 1992, was a special jurisdiction available to any citizen of Ghana, irrespective of personal interests. Under Article 2(1) of the Constitution, that is, under Article 2, Clause 1 of the Constitution, 1992, any person who was a citizen was entitled to bring a suit to the Supreme Court if he alleged that an enactment or anything contained in that enactment was inconsistent with or in contravention of the Constitution, and to obtain a declaration to that effect. Hence, other requirements for standing, like the dispute or controversy requirements or the personal requirements, were not necessary when invoking the jurisdiction of the Supreme Court under Article 2, Clause 1 of the Constitution, 1992. Consequently, the provisions of Article 2, Clause 1 were to be distinguished from those of Article 33, Clause 1, which dealt with the protection of human rights by the courts, and in which case the personal interest requirement was a condition for standing to enable the plaintiff to enforce his human rights and freedoms. The words "in relation to him" and "that person" used in Article 33, Clause 1 of the Constitution, 1992, implied that the plaintiff ought to have a personal interest in the litigation, which invariably also meant that there should have arisen a controversy or a dispute concerning an infringement of intended infringement of the plaintiff's said rights. Accordingly, the plaintiff in the instant case, who was a citizen of Ghana and who was seeking the interpretation of the Constitution, as well as its eventual enforcement, was entitled under Article 2, Clause 1 to invoke the special original jurisdiction of the Supreme Court. And then the quote ends. So the Supreme Court, in the case of Sam number 2 versus Attorney General, reported in 1999-2000 2 Ghana Law Report at page 336, lays it down clearly that in order to have capacity and local standard to bring an action under Article 2 of the 1992 Constitution to enforce the supremacy of the Constitution, all you are required to prove is that you are a citizen of Ghana. Now, it is important to mention that before this case of Psalm number 2 versus Attorney General, the court in Ghana had already had the opportunity to lay down this law in the case of Tufor versus Attorney General. Tufor is spelled Tuffur versus Attorney General, reported in 1980 Ghana Law Report at page 637. This case of Tufor and Attorney General was decided under the 1979 Constitution. And therefore, whenever he cites Tufor and Attorney General, you must be careful in not making it look like Tufor and Attorney General was decided under the 1992 Constitution. It was decided under the 1979 Constitution, and it was the Court of Appeal sitting at the Supreme Court. Now, the peculiar fact of Tufor and Attorney General was that the main issue in controversy was about Chief Justice Apalu, who there was a controversy about whether or not he was still the Chief Justice. Because when Ghana returned to constitutional rule in 79, Apalu, who was the Chief Justice during the military regime, he went back to Parliament to be approved as the Chief Justice, but Parliament refused his approval. He was disapproved. And therefore, because he was disapproved, there was an argument about whether that means that he's no more the Chief Justice or he's still the Chief Justice. Now, the plaintiff who brought the action to the Supreme Court, Tufor, he was not the one who was directly affected. Tufor brought an action to the Supreme Court seeking for a declaration that Apalu, as Chief Justice of the Republic of Ghana, there was no need for him to even go to Parliament for approval. And that because he was already Chief Justice before the return of the 1979 Constitution, he retained his status as such by virtue of the provisions contained in the 1979 Constitution. And because he retained his position as such, there was no need for him to even go to Parliament for any approval. Now, the main point I want to draw here is that Tufor himself was not the one who was directly affected by the disapproval of Apalu in Parliament. He didn't have any personal interest in the outcome of the matter. And therefore, when Tufor brought the action to the Supreme Court, an objection was raised as to his capacity to bring an action on that matter, because according to the Attorney General, he had no personal interest in the outcome of the matter. The court was quick in dismissing the objection, and the court holding that whenever any question arises as to the enforcement of the Constitution, an action could be brought by any citizen of Ghana, even if that person did not have a personal interest in the matter. All the person has to prove is that he is a citizen of Ghana. The Court of Appeal, sitting at the Supreme Court, speaking through SOA JSC, roundly rejected the Attorney General's objection and held that every citizen of Ghana had the right to bring an action to enforce the supremacy of the 1979 Constitution. And these are the words of SOA JSC at page 649 of the report. 649 to 650. He says as follows, and I quote, "The Constitution confers on every citizen of Ghana, by Article 1+3, the right to resist any person or persons seeking to abolish the constitutional order as established by this Constitution, should no other remedy be possible." This means that every citizen of Ghana has the right, constitutional or otherwise, to see to it that the constitutional order as established by the Constitution is not abolished or sought to be abolished. One method by which it could be determined whether a person is seeking to abolish the constitutional order is to seek for an interpretation of the Constitution as to the meaning or effect of a particular provision or provisions of the Constitution. There is a right, a duty cast upon every citizen of Ghana to go to the Supreme Court for a determination whether a person or persons is or are seeking to abolish the constitutional order established by the Constitution. The court in 2004 and Attorney General therefore held that the local standard to bring an action to enforce the supremacy of even the 1979 Constitution was given to every citizen of Ghana. And it's the same position in 2004 and Attorney General that has been reaffirmed in the case of Sam number 2 versus Attorney General, reported in 1999-2000, 2 Ghana Law Report at page 336. Now, the next question that has arisen still under Article 2 is that because in 2004 and Attorney General, the point has been made that local standard to enforce the Constitution is given to a citizen of Ghana. The question is whether persons who are not natural persons like human beings, but are rather artificial persons like companies, like body corporates, whether such artificial persons can also bring an action under Article 2. In other words, are body corporates or artificial bodies within the categories of people we can describe as a person that has been referred to under Article 2 of the Constitution. Now, a person under Article 2. The case law and the Supreme Court has indicated and held that that expression, a person, also includes artificial persons and body corporates. And you will see this in the case of New Patriotic Party versus Attorney General. 1997-98, 1 Ghana Law Report at page 378. What we know as the Siba case. In this case, when the New Patriotic Party brought an action under Article 2, seeking to enforce some provisions of the 1992 Constitution, an objection was raised on the basis that the expression a person that has been used under Article 2 should only be referable to natural persons who are citizens of Ghana, and that it should not include artificial persons. But like I have said, the Supreme Court held that the expression a person under Article 2 will also be interpreted to include artificial persons. This is the holding of the court that has been captured in the head notes under holding 1B, and I quote, "The Constitution, 1992, granted rights and freedoms to both natural and legal persons, and under Articles 3, Clause 4A and 41B of the Constitution. It was the duty of every citizen, both natural and legal, to defend and uphold the Constitution through the enforcement procedure under Article 2, Clause 1. Thus, Article 12 required that certain specified persons, including natural and legal persons in Ghana, should respect and uphold the fundamental human rights and freedoms enshrined in Chapter 5 of the Constitution. In the result, proceedings could be taken in court against all such persons for the enforcement of the fundamental rights and freedoms. Similarly, it was possible for legal persons to institute proceedings for the enforcement of their rights and freedoms. Thus, as provided under Article 18, Clause 1, a corporation could own property, and if its property was interfered with, as provided by Article 18, Clause 2, that corporation would be entitled to go to court for enforcement of its rights, either under Article 33 or under Article 2, Clause 1, for the interpretation of any enactment which adversely affected its property. In the circumstances, to interpret the word person as appearing in Article 18, Clause 1 and 2, to mean only a natural person, or to give the word its plain and grammatical meaning, would be to give it a narrow meaning, contrary to the rules of constitutional interpretation, which require that the provisions of the Constitution should be given a liberal and broad meaning, rather than a narrow or doctrinaire one to suit the changing social and political development of the nation. Accordingly, under Article 2, Clause 1 of the Constitution, 1992, other than the citizenship requirements, no limitation was placed on the nature of persons who might invoke the original jurisdiction of the Supreme Court. Accordingly, there was no logical reason for restricting the resort to the original jurisdiction of the Supreme Court to natural persons. And then the quote ends. So what the Supreme Court has essentially done is that local standard to bring an action to enforce the Constitution under Article 2. Even though in 2.4 an Attorney General, we are being told that the capacity and local standard is given to natural persons like citizens of Ghana. The Supreme Court, in the case of New Patriotic Party and Attorney General, Siba case, has extended the meaning of that a person to include artificial persons, so that artificial persons like bodies corporates can bring an action to enforce the supremacy of the 1992 Constitution. This same position that artificial persons can bring an action under Article 2 to enforce the Constitution has been reaffirmed in the case of Federation of Youth Association of Ghana, FEDIAC, versus the Public Universities of Ghana and others, reported in 2010 Supreme Court of Ghana Law Report at page 265. In this case of FEDIAC versus Public Universities of Ghana, Edinera JSC said as follows, and I quote, that consequently, the plaintiff as a registered body has capacity to bring an action under Article 2, Clause 1 of the Constitution. Quote ends. So this same position that has been affirmed in New Patriotic Party and Attorney General, the Siba case, has been reaffirmed in 2010 by the case of FEDIAC versus Public Universities of Ghana and others. So now, so far, we know one, that when any person seeks to enforce the Constitution, the court that has jurisdiction is the Supreme Court. We also know from 2.4 an Attorney General that local standard to bring an action to enforce the Constitution has been given to citizens of Ghana. We also know from New Patriotic Party and Attorney General, Siba case, and also FEDIAC versus Public Universities and others, that expression, a person under Article 2, can be extended to include artificial persons, so that bodies corporates can bring an action under Article 2 to enforce the supremacy of the Constitution. Now, the next question is that At which point in time can we conclude that a question related to the interpretation of the Constitution of Ghana has arisen? Now, the answer to this question is very, very important, because when you look at Article 130, Clause 2 of the 1992 Constitution, it provides that if a person appears before any court in Ghana, apart from the Supreme Court, so let's say if a person appears before the District Court, the Circuit Court, the High Court, the Court of Appeal, if he appears before any court in Ghana apart from the Supreme Court, and there's an issue that arises in such a court, and the issue relates to a matter or question that is related to the interpretation or enforcement of the Constitution, then that court must stay proceedings and refer that question of law involving the interpretation or enforcement to the Supreme Court for a determination. And then when you have gone to the Supreme Court and they have interpreted, they will refer the issue back to the trial court, and the trial court shall dispose of the case in accordance with the decision of the Supreme Court. So it means that to the lawyer and to the law student, it is important for you to know and find out when you can safely conclude that a question that relates to the interpretation and enforcement has arisen. Because the moment you identify that, it means you will have to stay proceedings and refer that issue to the Supreme Court for an interpretation. So what then is the test? Remember, we are also very careful that we don't set a very low benchmark, so that anytime any person goes before the Circuit Court and the District Court, they will just frame something to make it look like it is a question about interpretation of the Constitution, and they'll just use it to delay the proceedings so that the lower court will have to refer it to the Supreme Court for an interpretation. So there's a need for some clear-cut guidelines on how we can safely conclude that a question that relates to the interpretation or enforcement of the Constitution has arisen. Now, the starting point for this is the case of Republic versus May-Kain and others. Republic versus May-Kain and others. May-Kain is spelled M-A-I-K-A-N-K-A-N. May-Kain and others. So the Republic versus May-Kain and others. Reported in 1971, 2 Ghana Law Reports at page 473. This case lays down the position that it is not every time that the lower courts would have to refer a question to the Supreme Court for an interpretation, and that the lower court is not bound to refer to the Supreme Court when the provision in question is very, very clear and unambiguous. Means that if the provision in question is clear and somebody is trying to deliberately raise an issue of interpretation, the lower court is supposed to resist that invitation. Bannerman CG, who read the decision of the Supreme Court, said as follows at page 475. And remember, we are still on the case of the Republic versus May-Kain and others. This is what Bannerman CG said, and I quote: "We wish to comment that a lower court is not bound to refer to the Supreme Court every submission alleging as an issue the determination of a question of interpretation of the Constitution, if in the opinion of the lower court, the answer to a submission is clear and unambiguous on the face of the provisions of the Constitution or the laws of Ghana, no reference need be made, since no question of interpretation arises, and the person who disagrees with or is aggrieved by the ruling of the lower courts has his remedy by the normal way of appeal, if he so chooses. To interpret the provisions of Article 106 Clause 2 of the Constitution in any other way may entail and encourages references to the Supreme Court of frivolous submissions, some of which may be intended to stultify proceedings or the due process of law and may lead to delays such as may amount, in fact, to a denial of justice. So the Supreme Court, in the case of the Republic versus Mekankine and others, 1971 2 Ghana Law Report, is saying that if you are in any other court and anybody just makes any frivolous invitation to you, the judge, telling you that what he has framed is a question of interpretation of the Constitution, and so you should refer it to the Supreme Court for an interpretation, the case is saying that you must resist that invitation, because when the provision in question is clear and non-ambiguous, you can go ahead as a judge and apply the provisions of the Constitution, and you need not make any reference to the Supreme Court for an interpretation. This is the case of Republic versus Mekankine and others, 1971 2 Ghana Law Reports at page 473. So the Republic versus Mekankine is telling us that if the provision is clear, then there's no question of interpretation. But when can we, as lawyers and as law students, when can we safely conclude that a question that relates to the interpretation of the Constitution has arisen? All that Mekankine tells us is that if it is clear, the court can go ahead to apply it and you need not refer. But we still need an answer to the question, when should the lower courts refer to the Supreme Court for an interpretation? It behoves at this point that I rehash Article 130 Clause 2 of the 1992 Constitution. That says that where an issue that relates to a matter or question that is related to the interpretation or enforcement of the Constitution, and it arises in any court other than the Supreme Court, that court shall stay proceedings and refer that question of law involved to the Supreme Court. So for the lawyer, when do we conclude that a question that relates to the interpretation has arisen? In which case, a lower court would have to stay proceedings and refer it to the Supreme Court for an interpretation. We will have to refer to the case of Republic versus Special Tribunal, ex parte ACOSA. ACOSA is spelled AKOSAH. Reported in 1980 Ghana Law Report at page 592. This case plays a fundamental role and has thrown a lot of light that has been guiding the courts in determining when the courts can safely conclude that the question related to the interpretation or enforcement has arisen, in which case the lower courts would have to refer the issue to the Supreme Court for an interpretation. It is a very, very important case that all lawyers, law students must be very familiar with. This is the case of Republic versus Special Tribunal, ex parte ACOSA, 1980 Ghana Law Reports. This is what was held in the case. And I'm quoting from the headnotes. An issue of enforcement or interpretation of the Constitution, 1979, under Articles 1181A, would arise in any of the following eventualities. A, where the words of the provision were imprecise or unclear or ambiguous. Put in another way, if it would arise if one party invited the court to declare that the words of the article had a double meaning or were obscure or else meant something different from or more than what they said. B, where rival meanings have been placed by litigants on the words of any provision of the Constitution. C, where there was a conflict in the meaning and effect of two or more articles of the Constitution, and the question was raised as to which provision should prevail. And D, where on the face of the provisions there was a conflict between the operation of particular institutions set up under the Constitution. So we shall take each of these four requirements outlined in ex parte accusa and then throw more light on them. So ex parte accusa is saying that one, when the words of the provision, the constitutional provision, were imprecise or unclear, then we can safely conclude that a question that relates to the interpretation of the Constitution has arisen. Again, if you have a constitutional provision and two parties have placed rival meanings on the words of any provision of the Constitution, so that, for example, one party is alleging that when you interpret it, it's going to lead to conclusion A. The other party is saying that when you interpret it, it is going to lead to conclusion B. It means rival meanings have been placed by the litigants on the words of the provision in the Constitution. In that case, to ex parte accusa is saying that it is a question that involves the interpretation of the Constitution. So you have to stay and refer the issue to the Supreme Court. And then the third one is that you could have the same Constitution. Then maybe Article 5 and then Article 130. There appears to be a conflict between two articles which are in the Constitution. And there's a question as to which of the two should prevail. In that case, to ex parte accusa is saying that there is a question of interpretation of the Constitution, in which case you have to refer it to the Supreme Court for an interpretation. And the fourth scenario is where on the face of the provisions of the Constitution, there was a conflict between the operation of particular institutions set up under the Constitution. So, for example, institutions set up under the Constitution can be SRASH. It could also be NCCE, National Commission for Civic Education. If there is a conflict that appears amongst institutions established under the Constitution, that one too, ex parte accusa is saying that it is a question that involves the interpretation of the Constitution, in which case you have to refer it to the Supreme Court for an interpretation. Now, it is important to note that this case of Republic versus Special Tribunal ex parte accusa was decided under the 1979 Constitution of Ghana. So the question is, in view of the fact that it was decided under the 1979 Constitution of Ghana, can it still be deemed to be good law in light of the fact that we now have the 1992 Constitution of Ghana? The answer to the question is yes. Ex parte accusa is still good law and has been affirmed by the Supreme Court after the coming into force of the 1992 Constitution. So many cases have affirmed it, so many cases. In fact, in the case of Opong versus Attorney General, 2003-2004, Supreme Court of Ghana Law Report at page 376. the courts affirmed these principles that were formulated in ex parte accusa. Again, in the case of Bimpombuta versus General Legal Counsel and others, reported in 2003, 2005, One Ghana Law Report at page 378. The court once again affirmed the guidelines formulated in ex parte accusa. When you read the case of Bimpombuta versus General Legal Counsel, 2003, 2005, One Ghana Law Report at page 378, specifically at page 752, you will notice that Akufo JSC referred and quoted out in the extenso ex parte accusa and its guidelines, and she said as follows. This statement, and the statement here he's referring to is the statement of Enin JA in ex parte accusa. This statement remains good law today and continues to serve as a valuable guideline whenever the original jurisdiction of the Supreme Court is invoked under Articles 2 and 130 clause 1 of our present Constitution, 1992, and has been repeatedly applied by this court. She's not only endorsing the view of Enin JA in ex parte accusa, but she's saying that it has been repeatedly applied by the Supreme Court. That is why I'm saying that as for ex parte accusa, even though it was decided under the 1979 Constitution, it is still good law because the Supreme Court has repeatedly applied it under the 1992 Constitution. But I think I must be quick to add that even though we are saying that if a question that relates to the interpretation of the Constitution arises, you must refer it to the Supreme Court. When the provision of the Constitution is clear, then the lower court would be bound to apply the Constitution. Can just apply it without necessarily making a reference to the Supreme Court for an interpretation. So Akufo JSC, in the case of Bimpombuta versus General Legal Counsel and others, reported in 2003, 2005, One Ghana Law Report at page 738, delivered herself at page 753 of the report as follows, and I quote, in Eduamwa II versus Trum II, reported in 2000 Supreme Court of Ghana Law Reports at page 165. This court, in striking out the action therein, considered the original jurisdiction of the court and had this to say, per aqua JSC, as he then was, at page 167, 169, and 171, as follows, and I quote, the original jurisdiction vested in the Supreme Court under Articles 2, Clause 1 and 130, Clause 1 of the 1992 Constitution to interpret and enforce the provisions of the Constitution is a special jurisdiction meant to be invoked in suits raising genuine or real issues of interpretation of a provision of the Constitution or enforcement of a provision of the Constitution, or a question whether an enactment was made ultra vires Parliament or any other authority or person by law or under the Constitution. This special jurisdiction is not meant to usurp or to be resorted to in place of any of the jurisdictions of the lower courts. In other words, where our said jurisdiction has been invoked in an action which properly falls within a particular cause of action at a lower court, this court shall refuse to assume jurisdiction in that action, notwithstanding the fact that it has been presented as an interpretation or enforcement suit or both. For a large number of actions which fall within specific causes of action can be presented in the form of interpretation or enforcement actions or both. Now, it is very important to understand and appreciate that the 1992 Constitution is the fundamental and supreme law of the land, the provisions of which no other law is permitted to contradict. Therefore, all courts, tribunals, institutions, including the government, and all individuals are bound by the provisions of the Constitution. Accordingly, all courts, tribunals, and indeed all adjudicating authorities in Ghana are obliged to apply the provisions of the Constitution in the adjudication of disputes before them. In summary, then, one has the original jurisdiction to interpret and enforce the provisions of the Constitution is vested solely in the Supreme Court. Every court and tribunal is duty-bound or vested with jurisdiction to apply the provisions of the Constitution in adjudication of disputes before it. I'll take that portion once again. In summary, then, whereas the original jurisdiction to interpret and enforce the provisions of the Constitution is vested solely in the Supreme Court, every court and tribunal is duty-bound or vested with jurisdiction to apply the provisions of the Constitution in the adjudication of disputes before it. And this jurisdiction is not taken away merely by a party's reference to or reliance on a provision of the Constitution. So it is not every case that arises before the lower court that you must necessarily refer it to the Supreme Court for interpretation. If it doesn't fall within the guidelines under ex parte accosa, there will be no need for you to refer. And also bear in mind, even if it falls under the guidelines in ex parte accosa, but there's a previous interpretation on that position of the Supreme Court. If the Supreme Court has previously interpreted it, then why should you go ahead and now want to refer it again to the Supreme Court for interpretation? We want to jealously protect the hallowed ground of the Supreme Court, and we don't want to belabor the Supreme Court with any matter at all that anybody frames up as an issue of interpretation. We want to be sure that before an issue is referred to the Supreme Court, then there's a real and genuine issue of interpretation. And one point that I want to draw your attention to is this. You remember in ex parte accosa, Eninje made the point that when the provision is clear and unambiguous, there'll be no need. Then it means that you have to refer it to the Supreme Court for an interpretation. That is what Eninje said, that when the provision is unclear or ambiguous. And you remember what we said in Republic versus Bikantine, that when the provision is clear and unambiguous, there will be no need to make a reference to the Supreme Court. Now, any students of constitutional law would notice that today, in light of the modern purposive approach to interpretation, provisions in the Constitution that you might think is actually very, very, very clear would actually not be clear, and they will actually require the Supreme Court to interpret. For example, in the case of Republic versus Fast Track High Courts, ex parte trash, Dr. Anane Interested Party, 2007-2008 Supreme Court of Ghana Law Report, page 213. Even the word complaint that has been used under Article 218 of the Constitution, the Supreme Court held that it was a word that required the interpretation of the Supreme Court. So under the modern purposive approach to interpretation, provisions that otherwise you think are actually clear, they have been held to be provisions that will require the interpretation of the Supreme Court. And so the Supreme Court has had a warning that even though they encourage lower courts to refer issues to the Supreme Court for interpretation, the lower courts should be very, very slow and cautious in coming to the conclusion that a provision in question is very, very clear, which may not require a reference to the Supreme Court. In other words, if a case comes before you and you're in the High Court, do not be in a haste to say that, after all, the provision is very clear, so you can go ahead and apply it, because you've been told in Bimpombuta versus GLC that when the provision is clear, you can go ahead and apply it. The Supreme Court is saying that you should be very slow in coming to that conclusion, because that procedure that you even go through to even say a provision is clear, that procedure itself can even amount to you interpreting the Constitution. And so this point has been made strongly in the case of Republic versus High Court, General Jurisdiction, ex parte Senator Rollins, Ashite and NDC interested parties, reported in 2015-2016 Supreme Court of Ghana Law Report at page 53. In this case, Atuguba GSC, speaking for the Supreme Court, said as follows, and I quote, "It has to be realized that the initial stance of the Supreme Court, exemplified by cases such as Republic versus Bekankan, ex parte Yakusa, Eduama II, and Educhum, which laid emphasis on the plain meaning of a statute, preceded the new era of constitutional interpretation based on the non-dominance principle of purposive construction of statutes, particularly the Constitution. Indeed, beginning with Republic versus High Court, Fast Track Division, ex parte Electoral Commission, Metal Nunu, and others interested parties, 2005-2006 Supreme Court of Ghana Law Reports at page 514, the tide against ready referral for interpretation began to change. In that case, apparently very clear and unambiguous constitutional provisions were held to be referable ambiguities. Thus, in Republic versus High Courts, Fast Track Division, ex parte Trash, and an interested party, 207-208, Supreme Court of Ghana Law Reports at page 213, this court held that the word complaint in Article 218A of the Constitution was ambiguous and was referred to this court for interpretation. Indeed, in that case, the court held that a lower court ought not readily to assume that a constitutional provision is plain and unambiguous. It means that even though in ex parte Akosa, we are told that when a provision is unclear, you have to refer. And in Mekanka, we've been told that if it is clear, the lower court would have to apply it. That preceded the non-dominant era of purposive approach to interpretation. And now we are warning the lower courts that they should be slow in coming to the conclusion that a question is clear and therefore they will not refer it to the Supreme Court for an interpretation. This brings us to the end of our lecture of supremacy and interpretation of the 1992 Constitution of Ghana. Thank you.